This case is associated with the parental benefits that are available to the mother and father and the potential of the court for extending the legislation of for applying them more broadly. This case was presented before the Federal Court of Appeal and Supreme Court of Canada. Her Majesty the Queen and Canada Employment and Immigration Commission was the applicant and Schachter Women's Legal Education and Action Fund, Attorney General for Ontario, Quebec, British Columbia, Saskatchewan, Alberta, Newfoundland and Minority Advocacy Right Council were the respondents. Shalom Schachter pretended to a benefit that would allow him to take care of his child when his wife returned to work. Initially, he requested that he should be provided with the maternity benefits as per Section 30 of the Unemployed Insurance Act of 1917. The wife of the plaintiff gave birth to a baby on July 28, 1985, and she received a maternity benefit from July to November 1885. The plaintiff took leave for a period of 3 weeks and did not receive the pay. On 2 August 1985, he applied for the benefits under Section 30 and 32 of the Unemployment Insurance Act of 1971. He changed his request to the paternity benefit that falls under the Section 32 of the Unemployment Insurance Act of 1971. This law are directed towards the adoptive parents and can be shared between them. Natural parents not given same benefits as adoptive parents under Unemployment Insurance Act 1971. The request of Mr. Schachter was denied and his appeal was dismissed by the Board of Referees. He came to the federal court and represented an argument stating that the denial of his benefits is a violation of his equality rights stated under Section 15 of the Charter. Argument of leave was based on the needs of biological mother and also the disadvantages that the women face as they bear the burden of providing childcare. This is a very important aspect in the life of women that should be considered in front of governmental organization. In front of the Supreme Court, leave centered the argument that was based upon the remedy of extension. The argument stated that the provision promotes the equalities associated with the group that are disadvantaged by violation the Charter of Right and Freedom because this benefit exclude the other disadvantaged and stated that the court should not finalize the legalization unless it is sure that it is a promoting equality for both groups. The court should extend the benefits to cover the other disadvantaged group as well by making the best possible use of section 24(1) of the charter. Federal court's decision. The federal court stated that the plaintiff has a valid standing in the case and has also allowed a correct procedure. The decision could not be made as the evidence was not completely justified. The court needs to follow a procedure to define the fact and the legal issue. Further, from the presented evidence of Section 32, it can be identified that it is based upon the social importance of the parents. Spend their time at home with the adopted preschool chain irrespective of the gender of the parent claiming for the benefit. Therefore, this rationalize is also applicable to natural parents. Stated that the Canadian society is committed towards equalizing the role of parents for the care of their children. Federal Court of Appeals decision. Caution should be taken in interpreting the Charter of Right and Freedom. The Charter should not be considered as a complete constitution and the provisions are not subordinate. The entire constitution is considered as the statement for the will of the people that should be governed as per the defined fundamental principles and not the Charter alone. The major responsibility of the court is to identify the limits to which the legislation is permissible under the Charter of Right and Freedom. The Constitution of Canada does not give permission associated with the remedy that is crafted by the trial judge. When identified that the Section 32 is inconsistent with the Constitution, it is the duty of the trial judge to identify it to be of no effect and force. It was stated that finding presented that the Section 32 providing the unequal benefit to the parents was not challenged. The federal court identified that Section 32 was violating Section 15. What is the violation of Section 15? As the Section 32 violates discriminating between the adoptive parents and the biological parents. Important for the court to extend the benefits of the Section 32 to be the natural parent as well. It was upheld by the Federal Court of Appeal. However, the Supreme Court decided that the benefit to the biological parents should not be extended. The majority of the court agreed that the benefit falls under the category of being inclusive. They stated that striking the provision down could be inappropriate.
The court thought that this would deprive many people and Mr. Shigar will himself not get the desired benefit, although it was considered that in some cases it could be appropriate for extending the benefit to the groups that are excluded. The court identified that this is not the case that would require this extension. The court identified that the nature of the benefit and the excluded group associated with this case will result in the extension of benefit that will potentially bring changes in the entire legislative scheme. The Parliament was considered to be in a better position in order to make the decision about how the changes should be introduced in the provision. That the violation of the Canadian Charter of Rights and Freedom was not in the category of this narrow type of case. The case only falls into a very small portion of legislation that can be corrected by reading the material, which is a denied process itself. After all the hearings and arguments being presented, the court finally identified that the provision was invalid. However, the court said that the provision will continue to function for a defined period till the parliament decides what should be done and how the adoptive parents can continue perceiving the benefits.